Right, so we are live. Welcome everyone to another episode of Positively Family Law. Today, we are going to go over something that I don't even know much about. So it's going to be a learning process for everybody. Today, we are talking about G.A.L. or Guardian Ad Litem. So Heather, why don't you start by just telling us exactly what it means?
So a guardian ad litem, or also referred to if you hear G.A.L. Now, it's when it's spelt out, most people in the legal world will write capital G, capital A, capital L. I've heard this called all sorts of things, including G.A.L, including G.A.L. If you say anything like that, people will assume you don't know what you're talking about. So it's G.A.L or guardian ad litem. Those are what the letters stand for. And basically, it is somebody who gets appointed by the court. So you can hire them directly, but there has to be a motion made to the court to appoint one. So it has to be by appointment of the court. And a guardian ad litem will come in and do a complete investigation and basically usually make recommendations to the court about what should happen in your case. And we can get a little bit more into detail of how that is. But I think that's the broadest way to describe what a G.A.L is. It's a completely neutral third party who really digs into the nitty gritty of your case, because when you go in front of a judge, if you've been in front for a temporary order hearing, you typically have about 5 to 10 minutes to state your entire side of the case. And sometimes you're trying to condense 20 years, of life into a 10-minute argument. Whereas a G.A.L gets to really look at evidence. They get to talk with the different parties. They get to talk with collaterals, which basically just means somebody, say I'm going through an investigation and I say, I want Kayla to speak on my behalf. Kayla would be referred to as my collateral. So that's what they do. And then they create an entire report, gets submitted to the court, and it usually will help with settlement. And if it doesn't help with settlement, it usually gets introduced as an exhibit at trial.
Okay. So now, what cases are G.A.Ls usually brought on to?
So we're going to focus specifically on family law. So G.A.Ls can also be utilized within the juvenile court, but we're not going to focus on that aspect of it. So we're going to focus specifically in family law because that is what we do mostly. And that would be if there's a heavily disputed custody matter. If there's a guardianship, sometimes a G.A.L can be brought in. If there's a contested adoption, sometimes a guardian can be brought in. If there's a relocation case, say both parents are living in Massachusetts and one wants to move to Florida, and the court isn't going to make that decision based on what the parties are each saying, because it's, again, the narrowness of what the court is going to be looking at. There's so much more that goes into it. So sometimes they'll appoint a G.A.L to do that entire investigation and report back to the court whether or not they believe it's in the child's best interest to be able to move.
Okay, so typically whenever children are involved in a family law matter, that's usually when you'll see a G.A.L possibly be appointed to the situation.
Yeah, usually. There's outliers, but.
Gotcha. So now, can anyone just get a G.A.L, or is there a specific process and requirements for when they're allowed to come on or when they're appointed?
So what you can't really do is if, say we're married again and now we're getting divorced and we're arguing about the kids. And so we say, well, we want an investigation done. We're going to call a G.A.L and we're going to have them do an investigation. Without a court appointment, the investigation basically means nothing. So it has to be via an appointment by the court. Now that can be done a couple different ways. Number one, Kayla and I could agree that, yeah, we want an investigation to be done, and we submit what's called a joint motion or an assented to motion to have a G.A.L appointed. Now, whether or not, usually if there's an agreement, the court will appoint it, unless, let's just say we're getting along for the most part and we're just trying to run up fees because we hate each other, but really settled most of the issues. The court might look at that even if we're in agreement and say it's not worth it in this case and not allow it. But for the most part, if the two different sides agree to have a G.A.L appointed, the court will usually do that. So then even upon agreement of a GAL, you then have to decide who pays, because a GAL typically is paid out of pocket. So it's a private appointment. There are some cases where a GAL will get appointed and paid for by the state, but they're very narrow. If you're looking for a GAL, do not count on the state paying for it. More than likely it's going to be a private pay case. So if that's the case and we both want it and we both have some funds available, it might be that we agree to split the costs. Now it might be that maybe Kayla really wants the guardian ad litem to come in and I'm like, well, I don't really care one way or another. I just don't want to pay for it. Then Kayla might pay for it just to get it moving, or you bring that issue to the judge and the judge would decide based on a number of different factors. If there is a joint payment, and even if there's not, so let's go back to Kayla, you're like, okay, fine, I'll pay for it because it's that important to me. What you want to make sure you ask the court is that the payment is subject to reallocation upon the final judgment. And what that does is allow, if say I'm just completely in the wrong and I'm a jerk and I'm just making everything more difficult, the judge can look at that and say, Kayla, even though you paid, the money up front, now either Heather is going to be responsible for half of it or maybe even all of it. But if you don't have that subject to reallocation language, you can still go after it, but it makes it a much harder argument.
Back to that language and how important it is in family law.
And so then the other way would be if the court sua sponte, let's say it's so sua sponte means on its own initiative. So we're in court, we're arguing, it's a contested case. I'm strung out on drugs and alcohol. Kayla doesn't want me around the kids. I'm saying, no, she's lying, everything's fine. The court might say, this sounds like a case that really needs a guardian ad litem, and the court could appoint it. More often than not, one of the parties were motioning for it though.
Okay. So there is a process. It's not just calling and saying, hi, I want a GAL.
No, I mean, you can call different GALs. There's lists of them. You can call and find out, because not every GAL is accepting appointments. So because when you accept a case as a GAL, and I am a GAL, I've done the investigations myself before, the court or the parties will typically contact you and say, can you get this investigation done within a certain amount of time? And depending on the schedule, because like for me, I'm very busy most of the time. So whether or not I can fit an entire investigation in my schedule would dictate whether or not I can take the case. Then the other things you might want to look for is how much is the GAL charge? Are they typically known for going well beyond the hours allotted? And I guess let's start there. So with the court appointment, it's usually a document that comes, it's the appointment of the guardian ad litem. The appointment from the court will lay out the parameters of the investigation. So I think the first thing, if you're looking at getting a guardian ad litem, the first thing to know is what kind you're asking for, because that's important. If you don't ask for a specific kind, the court might just appoint you whatever. So there's two types of guardian ad litems. There's a category E and a category F. So a category F are typically attorneys. And what they do, and the difference is that in a category F, that investigation is solely focused on getting facts and basically putting all the facts of a case into a piece of paper, the report that gets submitted to the court. Mm-hmm. If on the appointment, the judge is requesting that the GAL make recommendations to the court, then the GAL will also include a section at the end that states what they think should happen in the case. And then most GALs, because you want to know how they get from the facts to their recommendations, will also include some sort of analysis, or summary of how they came to the conclusion that they came. Now, the difference here is with a category E, that's basically, if you think of F, facts, and E, evaluation. If you're dealing with a category E, usually you're dealing with some sort of mental health professional. So it's somebody who has been trained to understand what different diagnoses are, to understand substance abuse, to understand domestic violence. And not saying that attorneys can't understand that, but it's a different level of training. And within a category E report, what that GAL can then do is not only report the facts, but also come to some conclusions. So for example, if Kayla, I'm investigating you and I'm a category F and you're crying, I can report that you're crying, I can report what you're saying, but I can't connect that with you potentially being depressed. Whereas a category E could look at that and say, based on this situation, I believe she may be suffering from depression. So that's kind of the difference. If you're dealing with a situation where you want the professional to be able to make those types of conclusions, you might want a category E rather than an F. So those are the two main differences. And then within the appointment, they're going to give you the parameter of how many hours the guardian ad litem has to do the report. Typically, it's somewhere between 20 to 40 hours, I think is typical to start with. If the GAL needs more time, they usually have to either get the parties' agreement or request or motion the court basically for an order to expand to the time. You want to know what you're getting charged from the GAL. You know, every GAL charges a little bit different. Same thing as if you're hiring an attorney, you know, each attorney is usually going to have some sort of different hourly rate. Same thing with the GAL. And then whether or not you want to make sure for the court that you're asking for the recommendations, because that's really what you're looking for. And then also, if there are attorneys, now, if there's not attorneys on board, you just can't get the report. You have to go to court to be able to read it. Because a GAL report is what's called impounded. It's confidential. So the court doesn't just make copies and hand it out to people. I've heard horror stories of people posting it, you know, on social media and things like that. So they really try to protect that. But if there's two attorneys, as long as the box is checked, usually the GAL can send a copy of the report directly to the attorneys, which is so helpful. And if you're a practitioner, make sure that you're getting that box checked because it saves so much time. Other than that, you have to literally drive to the courthouse, get a copy. A lot of times they won't even let you take a copy. So then you just have to sit there, you read it, you take notes, you can't take pictures, you can't scan it, you can't, you know, it's very, very protected. So if you want a copy of the report, which is so much easier, you cannot pass it on to your client. So if you're an attorney watching this, just because you get it doesn't mean you can pass it off. Then it becomes your responsibility. But it just makes it so much easier in order to read it, analyze it, and discuss it with your client.
Yeah. So going back to what you said 20 to 40 hours in terms of the report. Now, is that the investigation portion or is that like?
That would be the total. So, oh, sorry, I started talking and missed the last part of what you said.
Just trying to figure out like what that 20 to 40 hours, like what that was about, whether that was like them investigating it or whether that was like, you know, them, like how long the report needs to be or how long, you know, they have in court to explain their report.
Mm-hmm. So basically the time frame is the time frame that you're supposed to conduct the investigation, which would be talking with the parties, meeting with the kids. Usually with the kids, you meet them with each parent so that the parents can't say that one parent is unduly influencing, as well as just to see how the kids react with each parent. So it's talking with the collaterals, it's reviewing any documentation. You know, I've done cases where I've gotten hundreds and hundreds and hundreds of documents that I need to review. And, you know, sometimes you can look at a document and say, I don't think this is really important. But a lot of times, if you get it, you're going over it because you don't know what's important and what's not. So the document review in and of itself can take a substantial amount of time. But it's the communication, it's the interviews. And then another huge portion of time is the report writing. It's taking all your notes from everyone that you spoke to and putting it together into a comprehensive report that makes sense and gets the court the information that they're looking for, as well as the recommendations. And, you know, I can't speak for every GAL, but I know when I've done the reports, a lot of times, and I don't charge for the sitting around and thinking, but a lot of times it's very, very difficult because you know what you're making a recommendation for can potentially influence a case. And it's not something I think that most people that are doing it, take lightheartedly. It's something that, and they can be very difficult because there's always two sides of a story. And as a G.A.L, which is very different than being an attorney, you not only hear one person's side, you hear the other person's side. Whereas with an attorney, you usually only really hear one side. But then you talk with the kids and you talk with the collaterals, and there can be 7 different stories. And so I found it to be very, very difficult, but the report writing can take a lot of time, so it includes all of that. Where it stops is typically once that report's submitted. So once the report's submitted, if there needs to be an update of the report, the court will typically reappoint the G.A.L to do an updated investigation. If say that the report and the recommendations don't help you settle the matter and the case goes to trial, one party might want to depose the guardian ad litem. Now, this is another thing as a practitioner, or if you're pro se, or even if you have an attorney and you're just trying to learn, what you might want to talk with your attorney about is making sure that oh God, now I forget what I was just going to say, and it was important.
Practitioner.
Yeah, no, I know. It was, what was I saying right before that? Come on, your listening skills are being tested.
No.
So it was the deposition.
Yeah, if it goes to trial and you want to.
I remember. So you want to try to get an order from the court, and this can be a little risky because you're hoping that the report comes back in your favor. But you typically want to get an order from the court that says that report, the G.A.L report, is definitely going to be admitted as an exhibit at trial. There was a case that happened a while ago where it used to be the burden of the person who was disputing the G.A.L case to call the G.A.Ls a witness, because then they can cross them, they can ask them all sorts of questions about, are they biased? Did they actually do a thorough investigation? Did they get stuck on something? Did they misinterpret information? Were they just wrong? So it used to be that, or typically is that the burden is on the person who is disagreeing with the report. There was a case a while ago where the court said, no, if you want the G.A.L report in, it's your burden to call the G.A.L as a witness and be able to lay the proper foundation for the report to come in because of rules of evidence. So depending on your judge, it's important to know who your judge is and where that stands. But if you get an order up front stating that the G.A.L report will come in as an exhibit, subject to, and I don't want to get too technical, but subject to different motion in limines where you can ask to have certain portions of the G.A.L report redacted. But then at least you know what the outcome is and not, do we have to do it? Because depositions, trials, that's going to cost extra. So that is not included within that 20 to 40 hours. You're going to be paying extra. And it's usually the person who's either deposing the G.A.L or calling the G.A.L as a witness that's responsible for that cost.
Gotcha. Okay, so now, obviously this is dependent on each case and what the details are and what exactly the parties need the G.A.L for. But like, what is it like? What is the G.A.L typically investigating? When can you give like an example of when a G.A.L would be necessary in a case and kind of what they're looking for when they're talking to the children or the parents or something like that? Again, obviously it is dependent on each case, but just.
Sure. So usually you see them a lot in cases where there's some sort of abuse, either of the kids or of the parties, or substance abuse, alcoholism. A lot of times you see them in those types of situations, but it's typically when you have almost like a he said, she said type of scenario. So when one person is, again, maybe you're accusing me of doing every drug under the sun, drinking every night, and I'm saying, no, you're basically full of crap. Like, none of that is true. What the G.A.L will do is come and investigate and try to figure out what is true and what is not true. Mm-hmm. So you see it in those types of situations, but a lot of times it's when it's very high conflict. where the parties can't agree. One will say the sky is blue and the other says, no, it's purple, and there can't be a meeting of the minds, or they can't see that two people could see something differently. So that's a lot of times when it will get appointed, because it tries to help eliminate some of that he said, she said for the court.
Mm-hmm. Would another example be like parental alienation? Like if that comes into play, if one parent is saying the other one is doing that?
Yeah, absolutely. And I kind of throw parental alienation issues, which is essentially just when one parent is interfering with the relationship of the kids with the other parent. I throw that under high conflict. So if I'm talking about high conflict divorce, it doesn't necessarily need to include parental alienation, but a lot of times that's where the parents are just, they just cannot meet in the middle somehow. So.
Well, it's like you said, they're a neutral kind of third party that comes in and investigates both sides to be able to tell the court what they find.
Yep. And so, I mean, a GAL can make all sorts of recommendations. They can not only recommend who should get custody, what the parenting plan should be, what the holiday plan should be. They can go into whether or not, one of the parties should go through some psychological evaluation or substance abuse evaluation, whether the party should be in therapy, whether the children should be in therapy. We've had issues where the parents are disagreeing on where the child should go to school. And sometimes there's a very narrowed focus GAL investigation of where they should go. I think another thing to note is that if your child is in therapy and you want the guardian ad litem that is assigned to your case to be able to speak with a therapist, there's another layer of guardian ad litem investigation. So there actually has to be a second guardian ad litem appointed, basically with a very narrow focus. It's usually like a limit of 10 hours or so for the investigation of whether or not the child's therapeutic privilege. So they have the right to confidentiality with their own therapist, even if the parents have been involved before. So even if prior to divorce or the custody matter, both parents were heavily involved, the child still has the right to confidentiality with what they say to their therapist. So because of that, when there's pending litigation, if the guardian ad litem, the main one, is going to be speaking to the therapist to get their thoughts of, what's going on with the child, what is the child saying, what is, the therapist's idea of what's best for the child. There needs to be a special GAL appointed solely to determine whether or not the child's therapeutic privilege should be waived. So there's that extra layer. It gets very costly.
Seriously, 2 GALs. Going into that now, I think I've run into this situation with people that have called in before in terms of like, well, I don't agree with what the GAL said. The GAL report is total crap. Like everything they said is wrong. Is there, like, what do you do about that? Is it going to be on them to dispute that? Or can they get another GAL? Is there a limit to how many GALs can be appointed on a case? If someone just disagrees with the findings?
So typically, if there's just a disagreement with the findings, that's not enough to get a completely new GAL investigation, typically. So if both parties feel, because we had one case where the GAL just wasn't responding, and it was literally taking like 18 months to get a report back, and which is way too long. Typically, a GAL shouldn't be accepting a case unless they can do it within, I think, about 3 to 4 months is the time limit that most GAL investigations are given. Now, some, back when the pandemic first started, of course, I remember I took on a case where I thought I was going to be able to get it done within 6 weeks. And then the pandemic hit, shutting down the country, and it ended up getting prolonged because of that. So there's certain things that might happen that prolong it that is not really anybody's fault. If there's a death in the family, there's a number of things that can come up, but typically you want to be able to get it done within a certain period of time. So in that particular case, there was definitely discussions of whether or not a different GAL should be sought, but then you go back into the funds that you've already put into the investigation, whether or not you want to re-put funds into a brand new investigation. But I think to answer your question, if you disagree with the report, I wouldn't say the burden necessarily comes on you to prove they're wrong, but it definitely shifts to usually you have to show why the certain areas. Now, it could be that you just feel they were completely biased. Maybe you learned something that I can't think of a good example right now, but maybe you learned something about them later on where you say, oh, there's no way they could have investigated our case and been neutral. That might be something to be able to get the entire case thrown out. The same as if, there's certain reasons why you can ask a judge to recuse themselves. There might be certain things that come along that you find out about a GAL that would be very important. Then there's a number of different things, and I won't get into the details of it because that could last another 4 hours. But there's definitely ways to be able to attack a report within motion in limines, which are basically motions that are heard before trial to either strike or redact part of the report. So you can get certain things taken out of the report. You can get sections completely removed, or you might have to wait until trial and basically address a lot of those on cross.
Gotcha. So, you mentioned trial is, can the GAL, is it like basically just in trial where they discuss everything, or could a GAL be appointed earlier than that?
So a GAL typically will get appointed near the beginning of a case. So usually the parties know that they might not be able to do this on their own. Now, there might be some things that maybe it just escalates. Maybe there's ongoing domestic violence. Maybe, somebody gets arrested for DUI and all of a sudden they uncover there's this whole issue they didn't know about. The GAL can come in most of the time prior to the pretrial. Usually you want the GAL report done by the pretrial because that's when the majority of cases are settling. So you want that report done because you utilize the information on it to decide whether you should settle or whether the case should go to trial. So it's really a settlement tool as much as it is a report for the court that can be utilized at trial. So it typically would happen then, and then updates might happen. So if you have your pretrial and then you wait 1.5 years to go to trial, there's a lot that can happen in that 1.5 years. So you might have the GAL come in and update their report to make sure that they know exactly what's going on now, because what's going on now might be very different than when they first did their report.
Gotcha. Okay. So I did ask the one question, like, is there a limit to how many times someone can request a GAL? Because again, it has to be appointed by the court. So like,
usually you get one shot. I can think of a case offhand where there was a request for the GAL. The judge didn't think it was necessary at that point, but then the case just kept getting more complex and almost became more conflicted as time went on rather than less conflicted. And the judge ended up appointing a GAL later. But typically it's not something you can ask for over and over again. Once you've asked for it, if it gets denied, you're probably not getting one unless there's a really good reason for it.
Gotcha. Okay.
Because it's not like trick or treating, it's not like, oh, I want a GAL, let's get a GAL. It's a huge expense. It's emotional. You're basically going through your entire life story again. So there's a lot to it. It's not something just to do it. You should really only do it if you really need to.
And you're also, it's not just you, it's you're putting your kids through it,
Right.
Especially if you're dealing with younger children. I mean, that's not something fun for them to do. And they don't really understand the severity of it. So to have them go through something like that over and over again would not be okay.
And I think another thing to kind of touch on is if you're going through a GAL investigation, number one, talk with your attorney, because I know we've spoken about the DCF investigation where anything you say will probably be used against you. So it's very important how you say things to a guardian ad litem. You might talk to your best friend. Your GAL is not your best friend. You still want to put your best foot forward. You want to be concise with how you're presenting your situation. The worst thing that can happen is the person who sits down and just starts blabbering and goes in 27,000 different directions, because as a guardian ad litem, then you're saying, okay, hold on. Not only is the cost going to run up, but then they're looking at it is how you're presenting the information. Is that how you live your life? Are you just so chaotic and scattered that you can't even present? Then there's certain things of how to say things. This is actually very important if you're dealing with different customs and nationalities, because certain things can be said in a certain way that is completely acceptable to that culture, but in a different culture can be taken very either inappropriately or very different, I guess is the best way to say it. And so making sure that you're relaying the message that you actually want to get across is just as important as what you're saying. Because if somebody basically misinterprets what you're saying, you have to wait until trial to kind of fix that. Another thing is just being extremely organized. A lot of family law comes down to he said, she said. It's what this person said versus this person said. Nobody else was there, because a lot of life happens behind closed doors. So if you can be organized and basically have as much documentation in an organized fashion as you can to be able to show that you are not lying, and that things are backing up your side and your position, you're probably going to get a much better result, as well as show the GAL that I am organized, I do know what I'm doing, and I'm credible and I'm trustworthy. So those are kind of things to keep in mind. GAL shouldn't be the person you're sending 7 emails or text messages to a day. Be concise. That's not their purpose. Their purpose isn't to be your best friend or just to be there for an information dump. You want to make sure that you're getting the information that's important. And that's where it's really important to speak with your lawyer, because your lawyer is going to know what they need to hear in order to make the decision. And a lot of times family law is so emotional. You can get very stuck on, Kayla, if you call me a bitch, and that is very insulting to me. And so I spend 3 hours explaining why I'm not a bitch, but not even focusing on the actual issues. I'm not going to get the result that I want. So that's where it's really important to have a game plan going into your investigation, into your meeting through that investigation. It's also important to make sure that if you're naming collaterals, if I'm being investigated and I say, oh, Kayla would be great to talk to. Kayla, I need to pick up the phone and say, Kayla, there's somebody that's going to call you. This is the process that I'm going through. It's also important to kind of know what they're going to say. I've surprisingly had conversations with people who party A will say, oh, this person will speak in my favor. And you get on the phone with party A, or, with that person, and they're like, oh no, party A is horrible. So make sure that they're actually going to discuss things in the way that you think they are. So
make sure you give them a heads up too. So
yeah.
Who is this?
Yeah.
All righty. So I don't think I have any other questions on my end. Anything else that
I think the only other thing, again, as a practical standpoint, because most people try to keep litigation and try to keep the process that they're going through with their spouse or their ex or whoever the other side is, separate from their kids. So most people try to shelter their kids. With a GAL investigation, they're in the middle. So a lot of times I get the question, and I get this more on a practitioner standpoint, is how do we tell our kids what's going on without telling them what to say, or basically scarring them or putting them in the middle. And what I've found, and every person, you have to understand the age of your children, you have to, how much do they already know regardless, but this person's going to come talk to you about our home life and what's going on, and just come and get to know you. And that's pretty much, all the GAL will explain their role. You just want to make it so that it's an open conversation for your kids where they feel that they can tell the truth and they're not going to get into trouble. Because a GAL can usually tell if kids are being coached.
Mm-hmm. Well, that's what they're trained to do. And, they know how to talk to the children. Mm-hmm. I think will help them, like you said, get the truth and understand if they're being told what to say or if they're being genuine.
Mm-hmm.
So, especially if, when you mentioned like category E versus category F, like, category E is probably they will pick that up really quick.
But it all depends, it depends on their background and their experience and what they're used to. So you'd think most people would. I've seen some fantastic GAL reports, and I've also seen some absolutely horrible GAL reports. So it's like anything in life. And I think I say this at least once every time we do this, there can be really great doctors and there can be crappy doctors. There can be great DCF workers and there can be crappy DCF workers. It depends. And that's why it's important, if you're spending the money, make sure that you're spending it right, and it's hard because you can't just look at people's GAL's report to say, oh, this one was good and this one wasn't. But there's, information, there's reviews out there, I'm sure. Usually reviews are tough because one of the parties hates the GAL, and that's usually the one that leaves the review. So I tend to think that if there's more negative reviews, it's probably better.
Even I think you could talk to your attorney in terms of.
Yeah, your attorney should know, definitely.
They've worked with in the past,
yep.
And they can provide recommendations that way. So, all right.
So if you have any other questions about guardian ad litems, feel free to either shoot it to us and maybe we can jump on another Zoom and, discuss those questions. Or if you're looking for an attorney to represent you within a GAL investigation, feel free to give us a call. Just call Kayla. She loves to talk with people.
Absolutely. Just call me. We'll all figure it out. So. All right. Well, thank you guys so much for watching, and we'll see you next week.
All right. Thank you.